We will go on the record in the matters 25 CM 103, 25 CM 106, 25 CM 167, 25 CM 206. State of Wisconsin versus Marcus Maxwell. The state appears through Assistant District Attorney Jose Vila in person. Mr. Maxwell appears in person with counsel Amber Sherwood. We're set today for a plea and sentencing. Ms. Sherwood, is this proceeding as such?
It is, Your Honor. I have a plea and sentence form filled out. May I approach?
You may. Thank you. Ms. Sherwood, can you please recite the agreement for the record?
Yes, Your Honor. The offer is to plead guilty to a disorderly conduct with a modifier of domestic abuse and 1 count of misdemeanor bail jump for a withheld sentence, 1 year of probation plus conditions including AODA and follow through, no contact with the victim, and court costs.
Okay, so domestic disorderly and a bail jump.
1 misdemeanor bail jump. Yes, Your Honor.
Misdemeanor bail jump for probation and withheld sentence. All right. Ms. Sherwood,
Yes.
before we continue, I'm just going to say, doesn't matter for this case, whatnot. I like to have that filled out on the back.
Yes, Your Honor. I apologize.
No, that's okay. I'm just letting you know in a gentle fashion.
Of course.
That I just prefer that because it's easier if the court needs to go back for some reason to check on what exactly the plea and agreement is. Okay.
I understand.
All right. Thank you. So, Mr. Maxwell, that is the agreement that you've reached. Is that correct?
Yes.
And I have in front of me the plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Did your attorney go over that document with you?
Yes.
Did she go over it thoroughly with you?
Yes.
Word for word?
Yes.
And so you understand everything completely.
Yes.
Okay. And that's your signature on the second page?
Yes.
You are pleading guilty to disorderly conduct with a domestic abuse enhancer and to misdemeanor bail jump. Is that correct?
Yes.
Okay. You're 23 years old. You have 12 years of schooling. You can read, write. You understand the English language. No drugs, alcohol, or other medications. No mental illnesses or disorders, correct?
Yes.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on this plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand here with 25 CM 103 disorderly conduct with the domestic abuse enhancer, the state would have to prove on or around June 30th, 2025 in Burnett County, Wisconsin, in a private place, you engaged in unreasonably loud and otherwise disorderly conduct, which tended to provoke a disturbance. It's a class B misdemeanor. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both?
Yes.
You also understand it has a domestic abuse surcharge, which means upon conviction, you will be fined an additional $100 surcharge, and you could be under the federal prohibition for no longer being able to use or possess a firearm for life.
Yes.
With regards to 25 CM 106, the misdemeanor bail jumping, the state would have to prove on or around July 8th, 2025 in Burnett County, Wisconsin, while being charged with a misdemeanor in Burnett County case number 25 CM 103, and having been released from custody, you intentionally failed to comply with the terms of your bond by having contact with the victim and or her residence. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Do you understand that there is an agreement that's been reached here between the parties and accepted, that you have accepted, which would be a recommendation to the court to place you on probation for a period of time with what's called a withheld sentence? Do you understand what that means?
Yes.
Do you understand what an imposed but stayed sentence is?
No.
Okay, a withheld sentence means essentially that if the court were to follow that, place you on probation with a withheld sentence, it means the court is withholding sentencing you on these two charges, okay? So that means the maximum possible penalty kind of hangs out over your head, and you could, if you're revoked, be sentenced at that time to up to the maximum penalties for both of those charges, okay? You understand that?
Yes.
Do you understand that with regards to an imposed but stayed sentence, that means the court will look at the facts right now. I'll look at the facts, I'll look at the cases, I'll look at you, I'll hear some history, and I will make a determination and say, I'm going to sentence you to this amount of time in jail, but stay it, kind of set it aside, place it over here on a shelf, and then place you on probation and give you an opportunity to do those things, etc. If you're revoked from probation, you do not come back to court. I've already sentenced you, and you would sit the time that I've already sentenced you. Do you understand that?
Yeah.
So do you understand the difference now?
Yes.
Do you understand that it is my discretion in what I sentence? I don't have to follow the recommendation. I could do any array of sentences if I feel that it's appropriate.
Yes.
And it could be an imposed but stayed, it could be withheld, it could be a fine, it could be jail. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, did you go over both of those criminal complaints with your attorney?
Yes.
In particular, those are those original charging documents that you got. And there's a section in both of those called the probable cause section, where it basically says what happened those days and why you were charged with the crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
So are you admitting here today that you in fact did engage in conduct that would be classified as disorderly in Wisconsin, and it involved a domestic relationship?
Yes.
Are you admitting here today that you in fact did commit bail jumping because you knew you were on a bail bond and yet you still had contact with the victim or residents?
Yes.
So you're pleading guilty to these charges because you are guilty?
Yep.
Ms. Sherwood, may the court use the probable cause sections of both criminal complaints to find a factual basis along with the statements made by your client?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yep.
Has your attorney represented you competently?
Yes.
Has she answered all of your questions?
Yes.
Has she looked at these matters thoroughly?
Yes.
Are you satisfied with her services?
Yes.
Did she discuss a potential, any defenses with you or a lack of defenses?
Yes.
And you discussed with her all that you're aware of or your thoughts on both of these cases?
Yes.
Are you and again, you're satisfied with her services?
Yes.
Do you have any questions for the court or your attorney before I proceed?
No.
As to count 1 in 25 CM 103, disorderly conduct with a domestic abuse enhancer, how do you wish to plead?
Guilty.
As to count 1 in 25 CM 106, misdemeanor bail jump, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights, what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 charges. The remaining counts and cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
Thank you, Your Honor. I believe the joint recommendation in this matter is appropriate. Mr. Maxwell is here taking responsibility for his actions. To my knowledge, these are misdemeanor level offenses, and I believe these are Mr. Maxwell's first criminal convictions, whether in Wisconsin or Minnesota. He does have an underage drinking ticket, I believe, in Minnesota, but that was from 2020. I do believe he has an issue with alcohol abuse, and that's what led him to this point. After receiving input from the victim, I believe a term of 1 year probation is appropriate. I think some supervision is necessary to give Mr. Maxwell access to programming and resources to help address that alcohol abuse problem, but to also include that no contact, include that no contact provision with the victim to provide them with some sense of security and peace of mind. As such, I would ask the court to adopt this joint recommendation. Thank you.
Thank you. Ms. Sherwood.
Yes, Your Honor, we ask that the court adopts the joint recommendation. This is indeed Mr. Maxwell's first criminal convictions, and he is here taking responsibility. Part of the deal is AODA. He is trying to get better. He is still young. And Your Honor, we're asking that you follow this recommendation. Thank you.
Thank you. Mr. Maxwell, I'm going to give you an opportunity to let me know anything you want me to know about the case, about you, about your perspective. If you want to, you don't have to though, but it's your only opportunity.
Like what I think about it,
Yes.
I think it was all like a big mistake at the time. I was going through a lot of employment problems, and her and I were having our own problems, but we were working on it. Alcohol is definitely a problem.
That's okay. You don't have to go on any further.
Yeah.
I can see and I can hear with kind of, I would say, the fluctuation in your voice and the tone. This is affecting you and impacting you greatly, that it has, that you went through a lot during that period of time, and that you perhaps were not having the best judgment, and you could have been having a little bit of a, this is going to sound worse than it is, a mental health crisis, because it sounds like you were having employment issues, you were having relationship issues, you were self-medicating with alcohol, all came at the same time and kind of imploded.
Yeah.
And you reacted probably how you wouldn't react if you were not consuming alcohol. And you engaged in conduct that you normally wouldn't probably engage in had you not been under those stresses and consumed that large amount of alcohol. I have to look at the seriousness of the crime, of both of the crimes, and I have to look at you, your character, your past criminal record. I have to see if there are any needs that you have for what's called rehabilitation, to try and rehabilitate you from these actions to ensure, or to try and ensure, that you're not going to engage in similar things down the road, okay? And I have to look at needing to protect the public, and that includes the victim in the cases. You seem like a nice young man. You do.
Yeah.
You seem like you just got hit hard, and you may have felt like you were almost at rock bottom at that point in your life. It's no excuse for how you responded and the conduct you engaged in, but it gives me an understanding of perhaps why and how you got there. I hear in your statement and in your voice, and I see from the expressions on your face, I notice those things, that this has impacted you, and it still is, and it still hurts. You are now convicted of crimes, which is not something you're probably proud of, or no, you're not proud of it at all. So now you've been convicted of crimes. You will be on probation and have certain restrictions. You can't have contact with the victim, which I'm sure is upsetting and hurtful as well. That takes a lot to get over. I think the agreement is appropriate to place you on probation, but before I get there, he's 23. Has there been any discussion as to expunction?
No, Your Honor, but state would not be opposed.
Wouldn't be opposed.
I
Okay.
was just about to mention that to Your Honor, if he could be eligible to petition for expungement at the completion of probation.
Okay. All right. So I don't know if you understand what that means either, Mr. Maxwell, because you're so new to the system. But if you complete probation, I'm going to place you on probation for the period of 1 year. Okay? If you complete probation successfully, that means no violations. You do what you need to do, and you don't have any other violations of the law. You don't do anything out of what you're instructed to do. You will have the ability to apply for expunction or expungement, okay? And that would be to remove this or remove it from your criminal record. It's not totally removed completely. It's just removed so the public can't see it. You still have those convictions on your record, but they're hidden, okay? And so as it relates to the domestic abuse surcharge and the potential federal prohibition for firearms, that may still come into play even if the matters are expunged. So I'm giving you that warning just so you're aware, okay?
Yep.
I think that it's appropriate to allow you the ability to have these expunged from your record because you're a young man. You were having a very difficult time. You weren't thinking appropriately. You were engaging in alcohol abuse. And I think that if I give you the ability to do this, that you'll benefit because you'll have these hidden from the public. They won't come into play when you're looking for jobs or you're going to school or you're doing those types of things. And you can be a better member of the community, a better contributing member of the community. I don't believe that society will be harmed either because with them expunged, you're going to be doing better, feeling better, and producing more positive things in society. So I will grant you the ability to have these expunged upon successful completion of probation, okay? With regards to probation, it's only going to be applicable to the bail jumping charge, the 25 CM 106. With regards to 25 CM 103, I'm going to assess costs in that matter. $443 in fines, fees, and court costs, plus the $100 domestic abuse surcharge for a total of $554 or $53. I don't know why numbers are not coming out of my mouth correctly today. So $543. With regards to the bail jumping charge, 1 year of probation, what I'm going to do is it's serious in the fact that you had contact and violated a restraining order, an injunction. That's serious because statistics and things that they're put in place, they're ordered for a reason, and violating means you're escalating the situation, you're escalating confrontation, and harm and serious risk could occur. Okay? And so that's why that is serious. You don't have a criminal history. You're, again, bad time in your life. What I'm going to do is if you are revoked from probation, I'm going to sentence you to 45 days in jail. Okay, 45 days. It shows the seriousness of the matter. It shows that it takes into account your age, your criminal history, those kinds of things, and your ability to rehabilitate. I don't foresee that you're going to be revoked because you're going to do what you need to do on probation and you're going to request this be expunged. And you're not going to have contact with the victim. So conditions of probation, absolute sobriety, no alcohol, either consumption or possession. That means you can't have alcohol in your home. No illegal drugs, substances, no paraphernalia. Testing upon reasonable suspicion or your agent or with your agent at your meetings, okay? AODA assessment and follow through. I am going to order, well, first I'm going to ask, are you engaged in any type of therapy?
No.
What I am going to also order is that you have a therapy assessment because it sounds like, it sounds like you were going through a lot and it sounds like you still are, okay? And so a therapy assessment and follow through recommendations from your therapist. I'm not going to order that you continue throughout the duration of your probation, but I'm going to say that you can be released from therapy at at the DOC's discretion. Okay? No contact with victim or residents or for employment unless approved by the DOC agent. Okay? $443 in fines and fees. You've already have a significant amount of bail posted, so those are all covered. You're all good to go. If you've posted it or whomever has posted it, you'll get the remaining amount mailed back. Okay? You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. So what you're going to need to do is when you're done here, you're going to come up to the clerk. You're going to get a form, a letter. You're going to take that all the way to the jail's day reporting. It's outside of the building, all the way to the back of the building, okay? You're going to provide your DNA. You may have the ability to have it expunged through a written letter to the Department of Justice, not to the court, not to me, to the Department of Justice. You can Google it. It's easy to do, or Ms. Sherwood can help you do that, okay? I'm not sure with the domestic abuse enhancer if you're going to be able to have it expunged from CODIS, at least until you're expunged from the crimes themselves, okay? So you may request it now, but you may have to request it later too, if that's what you're looking at doing. Any jail credit?
No, Your Honor.
Am I missing anything, but we are in victims' rights compliance?
Yes, Your Honor.
Am I missing anything, Mr. Avila?
I don't believe so, Your Honor.
Ms. Sherwood?
No, Your Honor.
Good luck to you, Mr. Maxwell. You can come up here and get that document and then you're free to go.